Very good. So very warm welcome, everyone. I'm absolutely thrilled to see you back to launch today the new series of our webinars for the new academic year. It's been quite successful last year. You have to know that all our Research Futures webinar are now on our website, on the website of the University of Portsmouth. So if you've missed a few, you can listen to them, see them again from the website. This webinar today is going to be recorded as well. We are delighted to welcome our colleague from Australia, Dr. Emmanuel Laryea, and you have to realize that it's midnight in Australia, so the contribution of Emmanuel to science and scholarship in international law and international investment law is really precious, it's really dedicated. A few words about Emmanuel. Emmanuel is an associate professor in the law faculty of Monash University and a member of the Monash Center for Commercial Law and Regulatory Study. His research and teaching interests are in international economic law, investment, but also banking and finance, trade, and generally commercial law. He has a particular interest for Africa. He's worked and published a lot on the African continent. He's originally from Ghana and he studied there before he moved to Glasgow, Scotland, obviously, and then he got his PhD from Bond University in Australia. He's also a consultant for a number of prestigious institutions, Australian Aid, also the UNCITRAL and UNCTAD. So I'd like to widely and immensely thank Emmanuel for his presentation. His presentation, as you're going to hear, is dealing with investment dispute settlement and how we could somehow enable host state citizen against investor, how we could bring host state citizen in an investor arbitration, knowing that obviously this is not something which is yet accepted. It's not a mere coincidence that we're starting with this topic, that we're opening the new academic year with this topic. As you know, I'm the director of the democratic citizenship theme. My name is Leila Shukran, professor of international law. And in this context, we have a particular interest for obviously citizenship, empowerment of citizens, democracy, rights, justice. So I'm very much looking forward to your presentation, Emmanuel. And without further ado, the floor is yours.
Okay. For putting me on and making this August forum available to me to present some of my ideas. I'm going to launch straight into it, and hopefully I'll get some questions from the floor to kind of enrich the ideas. I'm looking at later on developing this into a full-fledged publication. So basically, I'm going to, as Laila said, I'm talking about why developing countries or developing economies should enable host state citizens to be able to bring arbitral proceedings or proceedings in international arbitration against the investors. Now, that is something that is already there. And I'm proposing that that should be done. And then the next question is how to do that. So I'm going to go into the options for doing that because it is controversial and there are obvious problems, kind of a legal issue. So I'll tackle some of those. I might not be able to tackle each and every one of the legal problems, but hopefully by the end of the presentation, if there are any clarifications that are needed, I'll be able to sort those out. So just by way of introduction, the international investment community will agree, there's a general acceptance that the current system for settling investment disputes, which is ISDS, and in fact, I will actually narrow it down further to ISA, which is investor state arbitration. The reason being that in ISDS itself, even though it's used synonymously with ISA, investor state arbitration, actually that's kind of broad. It can take in all the other methods of means of settling disputes such as litigation, conciliation, mediation. So, but the dominant is the investor state arbitration, which it's most common, most known, and in fact has suffered a lot of criticisms as we speak. That is something that is subject to some sort of reform efforts at UNCITRAL at the moment, beginning from about 2017 when EU called on UNCITRAL to look into it. And so there are negotiations going on, meetings going on to try and reform that. Now, so obviously because of those criticisms, there are efforts to reform. But going on, or the way it is, the focus of the reform as it is currently is towards trying to bring in some kind of balance in with respect to that's if at all, if we get there, with respect to investor rights against the state. That is the main focus of that. And my point is that there's a major deficiency which seems to attract little interest, or on which there's been little progress, if at all. And it doesn't seem to be an issue that is being considered broadly at the UNCTAD kind of discussions for reform. Now, I have tried to kind of get that through some angles. I haven't made any headway. So, and I know some others who they have tried some other things. But anyway, so in effect, what this deficiency is that the current ISA system gives investors the right to bring arbitral proceedings against host states who are alleged to have impaired their investments in some way, and to be awarded compensation. That's basically what it is. Now, the issue, or the part that I think is being left out, is that yes, host states, and a lot of host states do bad things, can injure investors, and for which the ISA gives an avenue for remedy. And by avenue, I mean international forum for remedy. But investors too can cause harm. Investors can cause harm to host state citizens, host state environment. We know it happens. And now the notorious one, which I will probably come back to again, is Shell in Nigeria, Delta area, pollution, moving people off their lands, damaging waterways, making life uninhabitable on local lands. I mean, it happens, all right? So investors can cause harm. Now, currently, the system is such that if the investor is injured, the investor can go to international arbitration and seek that remedy. If the investor causes harm to the investor, to host state citizens, such as the example I've given in the Nigerian case, then the host state citizens are simply required to seek remedy in their domestic jurisdiction, the domestic courts. Now, we've got to remember that there is a reason why we have ISDS, interstate arbitration, in international forum. The reason being that most of those domestic systems in developing countries are actually weak. They are compromised. They are not, independent. And there are issues there. And so investors want to go to an international forum that they can trust, that will give them justice, as they might say. The trouble is that, unfortunately, most state citizens who are harmed by investors, they don't have that international forum, but they are left to simply seek remedy in those systems, those very jurisdictions or forums which investors think are compromised and are weak and can't dispense justice. So on the one hand, investors get a good forum to go to, if I may be allowed to say so, whereas harmed citizens by investors go to the weak forums. And as we, as in the examples I'll give, most of those forums don't give leave harmed citizens without adequate remedy, or without a remedy, if any. So what I'm proposing is this, and I know that about arbitration and it's being reformed, and that is fine. And I support some of the reform efforts. But what I'm saying at this stage is that whatever forum, whatever reforms are done, whatever improvements are done, it should not be left to just investors to seek remedies. It should be open up to potential harmed citizens to also have access. Just as investors who are often private citizens or corporations can go to those forums to get a remedy against states, harmed host state citizens should also go to those same forums. So I'm going to concentrate on arbitration because that's the one that is used most used currently. But then what I'm arguing here will be applicable to any multilateral investment court that may eventuate. And I know that the antitrust system is considering that as a possible option. Now, if that happens, yes, it should be made available to investors as well as harmed host state citizens as well, so that all can seek a remedy from that in that forum. All right. So basically, I'm proposing what I'll call a kind of a wider or a broader system for settlement of investment disputes, which I will kind of I will term as said, and that should be open to both investors and host state citizens. Again, as I've stated, I'm just going to concentrate on arbitration because that's the one that works at the moment. And if there should be multilateral investment courts, that should be open up to them as well. So I'm going to look at why developing countries should enable that and how or what they can do and how they can do it. So basically, that's what I'm going to look at. I don't need to go into ISA. I have a little bit of a definition there, but we know what it is. Basically, investors can go to arbitration and sue government or bring governments, bring proceedings against governments to get awards if the and usually to be award of damages if the host state is said or is considered to have breached the impaired investment of the investor. But stated again, that has tended to be an effective forum for investors, but that is not available to host state citizens, and therefore host state citizens are left without adequate or good forum. Host state citizens in some countries, especially weak developing economies, are left without a good forum to get remedies. And what I'm proposing is that there should be a kind of a direct access by host state citizens to international forums to also seek remedies against the investors. Currently, they either have to go to a domestic court, or sometimes you might say the spousal system. That is, if the domestic court are not good, or the investor doesn't have assets within the jurisdiction, then maybe their host government can then go to international courts against the investor on their citizens' behalf. But as we know, often the governments of developing countries are actually part of the problem. Often they are part of the problem. So they are not going to help their citizens, especially when they are part of the problem. And there are a lot of cases in which they've shown to be disinterested in the interests of their own citizens to that extent.
Sorry to interrupt you, Emmanuel. I think you might have stopped sharing your slide. I don't know if you still have.
Oh, really?
So
sorry, I don't know what has happened.
Issue. Okay. It doesn't really matter because everything you say is very much easy to follow, but you might want to share your slide.
Again, I think the screen, I'm using two screens here. It looks like it's on. So let me just give me a minute. What happens? So I'm going to go to the screen two.
Excellent.
Is it coming?
We're back. If you could show it. That's perfect. Thank you so much.
Okay, all right. Is it working now? Yeah, okay, all right. So I'm sharing on that on the another screen. So if I'm looking on the side, it's just because I'm using two screens. Okay, so so as I've stated, what I'm suggesting is a shared system, and it could be under the current investment arbitration system or in a multilateral investment court. Now, actually, this proposal itself, I have already kind of advanced that in a journal article came out in 2018 in the Boston College Law Review. So I've cited it there. You know, the title was "Making Investment Arbitration Work for All: Addressing the Deficits in Access to Remedy for Wronged Hosted Citizens through Investment Arbitration." So the proposal itself is not kind of not is there. It's detailed. It's quite a lengthy article. So if you're interested, I will leave you to any interested person to read it, and I can email it to you. It's free. It's available on the internet as well. In effect, that system, what that system will do is that it will allow investor state arbitration as we have currently. So that's the ISA, and I have the tick there. But the addition will be to allow host state citizen investor arbitration. That's the new proposal. Now, there is a part of it and say, well, should we allow hosted governments also to bring arbitration against the investor? Well, there's not that can be debated, but I'm not focusing on that because my interest is mainly for hosted citizens who are usually the victims who are left without a remedy. Now, this idea itself, there are some variants of it. You know, some people have published some things along kind of either lines. So Amado and Ken and Rodriguez published a book by CUP Cambridge, which is arbitrating the conduct of international investors. Now there are some big flaws in that book. I saw a lot of kind of problems with it. Then Alexandra Curie has also kind of published an article which also looks at some aspects of that. In fact, Alexandra was at the same conference I was in Boston, and so her paper actually came out in the same issue that mine also came into the Boston Law Review. And then there are a few others who have kind of now come up with some other ideas. But the main thing I want to concentrate on is that with my proposal, there are obvious challenges, legal challenges. And they are principally jurisdiction and the substantive law issues. That is, if I'm in arbitration, we know that arbitration jurisdiction is conferred by kind of consent. So how do you get an investor to consent to arbitrate to arbitration with a host state citizen? How do you get that? Because host state citizen are in the country, investor comes in. How do you get investors' consent? I have looked at 6 possible ways of getting that. And some of them are not practical. Some I think are practical, and that's the one. Those are the ones I will focus on. So ad hoc, for instance, case by case. An investor comes in, causes harm, then host citizens say, "Oh, we want to take you to arbitration." The investor says, "So I consent to arbitration." Obviously, that is not going to work. Most investors are not going to consent at that point to be sued. All right. Second is if an investor comes into a jurisdiction and voluntarily say, well, you know, I make a standing offer of consent to arbitration. Any citizen who wants to take me to arbitration can. And that again is unrealistic, but you know, it's an option. Okay. They can also make an offer of consent in some other ways, such as in an investment contract between the government and the investor. Now, of course, not all investments are underpinned by investment contracts between a government. An investor can come in and not just and have an investment without necessarily having a contract with government. But if they have a contract with a whole state government, then maybe they will be made to make an offer to arbitrate in that contract, and that will stand to hold them. That will stand like a standing offer, which will be available to citizens if they need to take the investor to arbitration. But I think, I mean, the last three are probably a bit more realistic, and one will be that the host states can enact a law in which it says all foreign investors are deemed to have consented to arbitration initiated by host states. So if you once you invest in the country, you are deemed to have accepted that. So that will be a law enacted by the host state. The fifth one will be a declaration in a mandatory domestic licensing system. So before a foreign investor invests, that foreign investor will be required to obtain a license. And I know that in Australia at the moment, Foreign Investment Review Board requires almost everyone to, since COVID, to obtain some sort of approval. And that in that approval system, the government then have a standard clause there which says that, well, this license is given for you to invest, and basically these are the terms of it, including you consent to arbitration by hosted citizens should you harm them, or should anybody, any investor, any citizen proceed, go to arbitration against you. Now, the last one, which is the one I will be constructively known, is the IIAs signed by host states and home states. So we know bilateral investment treaties, and it could also be in a multilateral treaty, that the host states in a treaty will say that if a foreign investor goes to the other country to invest, that investor has consented to be to arbitration by citizens of the host state. To the substantive law issue, the question then is, even if you go past consent, what law would the tribunal administer? What law would they use to determine liability or remedy? Maybe the domestic law of the whole state? Would it be international law? Or would it be both domestic law and international law? Which law? On the basis of which law do you determine liability? I think that there are possible ways, and I have about 6 there. Again, just to go through those very quickly. One will be that you say the arbitral tribunal will use the whole state's law. So if you go, let's say I'm from Ghana, so I'm going to give you an example of Ghana. You go to Ghana, you invest there, you breach, you cause harm there, and Ghanaians, some harm citizens go to arbitration. The arbitration will look at the Ghanaian law to say, have you breached Ghanaian laws and caused damage and caused harm? The other one is to look at the home state's law. So you look at the standard of behavior required in the home state of the investor. Or you look at the seat of arbitration. So if the arbitration is seated in, let's say, Singapore, then use Singapore law. But this will be a bit too artificial, I guess. But those are the first three. But I think that the next two are a bit more kind of, might be a bit more balanced. And that is, can you use general principles of law? So I'm not just talking about human rights abuse. I'm talking about torts, for instance. Okay, so almost will have some system, a law of torts. Now, in common law, we call it torts. In other jurisdictions, it might be called delicts. So are there general principles of law? For instance, negligence, okay, tort of negligence. And therefore, if the investor is deemed to have been negligent, then that becomes a general principle that is applied. Is there a general principle like that? And can that be used? But the fifth one will be that the risks are on the investor in a IIA. And of course, original for first or second generation IIAs, we didn't have investor obligations. Now we're beginning to get some instruments that are beginning to impose some sort of obligation on investors. I will give you an example of one or two. Having said that, we all know that some of this, and there's been some effort already at the international level. through UNCTAD, UNCITRA, OECD. Most of them have ended up being kind of soft proposals that haven't really taken ground. So it's what I'm saying, going to work. Well, I think that there is another. It is possible. It is new, kind of a new angle, new idea. So hopefully it can work. But let me give you these examples here. So, for instance, if you take the fifth one, so remember that I've said that the fifth one, which is IIS, will be one of the sort of ways by which you do that. And to do that, the host state and home state would have agreed in an IIA that investor consents to arbitration, and here are obligations imposed on the investor. And if the investor breaches those obligations, then host state citizens can bring a case against them before arbitration. Now, if you use IIAs, it will be kind of the most effective way of doing that. Now, other examples of that, the answer is, partially yes. The Morocco-Nigeria BIT, which is hailed as one of the kind of one of the progressive ones that had investor obligations, goes back to 2016, but it's not in force. The Pan-African Investment Code purports to do something like that. That also came out in 2016. That also is not a treaty per se, it's only a model IIA. However, there's a little known, less publicized IIA, which is the Act on Investment of 2008, which actually has investor obligations. And that came into effect, in fact, it was signed in 2008, came into effect in January 2009, and it's available on the UNCTAD web hub, policy investment hub. I just want to go through a few of the kind of clauses there. So Chapter 3, for instance, has obligations on investors. One is they have to abide by host states regulations and laws. They have to do impact assessment, pre-establishment. They cannot engage in corruption, and if they go engage in corruption, that will be a criminal. They have to uphold human rights. So Article 40, for instance, say they have to uphold human rights in the workplace and in the community in which they are located. And they have to uphold fundamental labor standards as stipulated in ILO documents. They have to maintain kind of national and international accepted standards. They have corporate social responsibility obligations, which they must uphold. And they have liability in civil actions. Unfortunately, Article said that civil liability actions will take place in a judicial process of the whole state. So it brings it back to square one. Really, you have to, these actions will have to be brought in the domestic courts of the whole state. I'm arguing that you should take it out of there. So at least that's a limitation. But it's also the end, Chapter 4 talks about whole state's obligations as well. And the home state also has rights and obligations. And one of those, which we find in Article 29, is that investor liability kind of imposes a liability on an investor in his home state. So, for example, if you kind of get an investor in the host state, you can actually chase the investor up in his home state and bring an action. And if that happens, I was talking about the which substantive law will apply. Actually, in Article 29, it says that the home state's courts will apply the host state's law to determine liability. So that's kind of like a step forward from where we are, but again, it's not arbitration. It's talking about domestic courts. So there are limitations in there. Now, it also talks about settlement of disputes. Somehow it talks about arbitration, but then narrowed it down to national court. So it looks like the system is being set up such that it has to be arbitration in domestic courts. I don't fully understand why they did it that way. but it also gives issues of transparency as well. Now, I'm conscious of that time is going. I would like to allow plenty of time for questions. So I'll quickly run through this. So basically what I'm saying that this starting point, but there are shortcomings. And the shortcomings, one of the main shortcomings is that unfortunately, the ECOWAS Act does not give direct access to arbitration by harmed host state citizens. They can have direct case against them in domestic courts or the domestic courts of the home state or host state, but not arbitration. So it doesn't answer my question. But hopefully that's something that can be proposed for a change or for reform in there. Another question I'm toying with whether harm can go to the ECOWAS Community Court of Justice against investors. Now, I have to say I don't have the answer to that, but it looks like it will be unlikely because most defendants in that court are member states, rather than private citizens or private investors. So I don't think that will work, but that's another thing that may have to be looked at. Now, I did point out that there's been a lot of other efforts at the international level that has been ineffective so far. There's a long history of that through the UN. I mean, the latest one is the Hague Rules on Business and Human Rights, which was promulgated at the end of last year. But that's early days yet. We don't know whether it's going to be effective or not. The question that you may ask is would it work? I will say it's feasible. It can work if it is appropriately formulated. We should remember that once upon a time, investors too didn't have direct access or direct course against host states. All right, ICSID brought that up. So once it's been done for investors who are private citizens, it can be done for host state citizens as well. It's a matter of taking the steps to do that. And what I'm proposing avoids a lot of the problems that have beset most of the efforts so far. I think that time is kind of not ripe for a change. Why? Because one, there's now some sort of consensus that the system needs reform, and reforms are going ahead. Developing countries have changed their kind of perception about this whole system, and there's some sort of support from academia, CSOs, for rebalancing the rights of investors and citizens in international investment law. And I will leave you with a kind of a quote in case you think that what I'm is too far-fetched, too theoretical, and too out of this world. Say William Randall Kramer in 1905 when they were proposing for an international court of justice. And this is what it says. When we formulated a plan, the High Court of Nations, which now we say is International Court of Justice, we were left to scorn as mere terrorists and utopians. We proudly point to the fact that the Hague Tribunal has been established. And this was even long before ICJ. Remember, this was 1905, but Hague Tribunal was established by then, and the world has moved on a lot. So I hope you don't think that this is too theoretical. Hopefully, you can see some merit in it being a possible avenue. All right, I will end there and allow questions.
Thank you so much, Emmanuel. I know we have questions already, but thank you for concluding on this very hopeful note and reminding us of the importance of history in international law, which is to some extent relatively young discipline if taken from a truly, generally universal international perspective with the developing world at its core. I very much like the fact that you navigated between the different disciplines of law, and you referred to contract law, to tort law. There is great need for creativity, as you said, and very much like the fact also that you reminded us that the African continent, and we've seen that together in a number of webinars in the past few months, the African continent has always been very creative, legally speaking, and the ECOWAS, which is an old, so to speak, old text, because as I said, it's 2008 compared to, the new initiatives and the new international treaties in investment, was already very much daring, but the problem, as often, is obviously implementation. We'll talk about that later. But I don't know whether you've seen, it's a very new development, interestingly, that in the new US, Canada, Mexico trade agreement, there is something really interesting in relation to labor. There is what it's called the US the Facility Specific Rapid Response Labor Mechanism. And according to that, actually, a number of actors, not necessarily the victim, but, typically trade union, can bring a claim. It's not a typical investment claim in an arbitration, but can bring a sort of claim. We're more in a maybe mediation type of thing. If labor rights violation have been ascertained. So change is possible, as you say. We have to be hopeful, creative, and also active in this regard. So I'm going to read the question that we've received. We've received a number of questions for you, Emmanuel.
Yeah.
Very much our colleague.
Sorry, let me get a pen and paper to write the questions down. So I don't miss them. Yeah. Okay.
Tangina. You can see the question, Emmanuel, on your right in the chat box, but I'm just reading that for you. It's just easier.
Okay.
But I'm reading that for you, so don't worry. First question from Tangina. Don't you think that including rights of the host state citizens to bring action against investor in IIAs will be a challenge for the states with weak bargaining power?
All right. Look, I that is true, but let's not forget that once something, if you go back maybe 30 years, 30, 40 years, there was this kind of a clear, or what appeared to be a clear distinction between capital exporters and capital importers, and capital exporters wrote the investment kind of treaties as though, oh, it is to protect our investors going there. All right. So all the old generation were giving sweeping rights to investors, no obligations whatsoever. But in the last about 20 years or so, 15 years, we know that now even developed countries who initially thought that IIs will not be used against them have turned, and they now kind of beginning to bring in kind of some balancing. So 40 years ago, we say there was a kind of a weak states and strong states, and these people are looking at this in business interests, and these people are looking at their own interests. I think they've moved into the middle a bit more now, and so I mean, like in fact, Leila, you gave an example of the new U.S., Canada, Mexico agreement ready. All right, now you have two developed countries, okay, Canada and the U.S. there, and yet they are bringing labor rights in there. So I think there is now a bit more willingness on the part of even both developed and developing countries. So let me say most developed countries to kind of consider some of these things. So I don't think it's out of the question. For some countries, it might be a bit of it might be have to be negotiated, but I think the world has moved a bit from 40 years ago. So I think it's still worth trying. And of course, as we saw in the ECOWAS one, you might say, well, it's among all developing countries, so maybe it was easy. But I don't think that I don't think it's out of the question. I think you can try.
Very good. Thank you so much, Emmanuel. Another really interesting question from Samir. Would you recommend fixed cost arbitration to limit costs to citizens bringing an arbitration claim? We know that the cost of an arbitration is very high, but it's not necessarily an arbitration, I suppose, that you have in mind, is it?
Oh,
Samir, sorry.
actually, I am. I just want to look for. I am actually going for arbitration. It could be in ICSID. It could be in any other forum. Just like investors do go to arbitration. I know that when I've thought about this, I've thought about whether, and some people, in fact, when I've just discussed with people, some people have said, "Oh well, but those citizens they are poor, they cannot afford the cost of arbitration." I think there are a number of answers to responses to that. One is, in the first place, they say some people cannot afford, therefore they shouldn't have the avenue at all. I think what we want is the avenue should be there. First place, we shouldn't deny them the avenue. At the moment, they are denied the avenue. Now, actually, when I think at some point I lost some of the slides, so I didn't show this particular slide, which I've now brought on to show how citizens have prepared to go to courts, which is in the US. So, cable case, for instance, parties have gone to Netherlands, they've gone to the UK, all right, for cases. These are in courts, and you cannot say that litigating in the US or Netherlands or the UK is cheap. It's not cheap. All right. So if citizens can, you know, can actually be so desperate that they want remedy that they go there, it means that if they have better avenue, and most of these cases they fail because the law and circumstances are such that the courts then say that they don't have jurisdiction or they cannot hear the case after wasting a lot of money. The harmed citizens are left without a remedy. If there is arbitration where they know that they have jurisdiction, I'm sure they will spend money to go there, and I'm sure they will. There will be ways of affording. It could be maybe assistance from CSO. There could be. Look, I don't want to go down the path of third-party funders, but actually, you can get third-party funders who will say, "We want to fund this group. Exactly. If they make their money, we get some out of it, and they get some." So I think the mere fact of having the avenue in itself, it's there will be those who can then help them to fund it. And the last, actually, another reason I was going to give, and I know that I jumped a few things, I didn't didn't look at it. I think that a lot of investors get to cause harm because they get away with it. So like Shell is doing it for the last 40 years. I think if they knew that there was an effective way of getting remedy against them, they will change their practices because they are deep pockets. There are those who will come after them, and they will know that it's not worth causing harm. It will be better for them to operate by sound international standards and avoid harm. And that itself will be a good remedy.
Yes, you're right. And these litigations have been extremely costly for the investors as well. I'm speaking about, Texaco, for instance, in Ecuador, the many millions, if not maybe now billions, they've spent for litigation and a very big team of lawyers. And as you were saying, Emmanuel, when you think about the Alien Tort Claim Act, the victims, they were not going alone, really. They were supported by groups, NGOs, etc., which might also pose a number of problems, but you're right. Another very interesting question, you almost responded to that, but from Samir, which seat of arbitration is currently suited to protect the rights of individual versus the legitimate interests of investors?
Without a seat of arbitration. Please, can you?
Which seat of arbitration is currently suited to protect the rights of individuals versus the legitimate expectation of or legitimate interest of investor? Well, I mean, it's a general question. The seat of arbitration, I suppose.
Well, I mean, I guess arbitration, the seat of arbitration doesn't determine a lot. So, I mean, ICC arbitration can be situated in Singapore, can be situated in different jurisdictions. So I am actually not proposing a particular seat. The main thing, if you know of the institutional arbitral system, let's say ICSID, the parties will determine which seat to go to. And but I note interestingly, actually, when Philip Morris brought a case against Australia,
Exactly.
somehow arbitration became a big issue. I think Philip Morris was arguing for Singapore, Australia was arguing for London. And that itself costs a lot of money to just argue that. Eventually, the tribunal situated it in Singapore. So, but I'm not sure what difference it made for Australia to have it seated in London or in Singapore. Ultimately, it was under the PCA, which is the permanent arbitration. So I didn't understand the difference between. I don't think seat makes a lot of difference, but I could be wrong. I'll be happy to get in there.
It's my take, but I might be wrong. But it's also relates to the arbitrators, right? The choice of people, maybe sometimes.
No, to choose one, one each, and then the nominees of the parties would then choose the third arbitrator who becomes the president. So, yeah, I would like to look into it. I'm not sure if the seat makes a lot of difference, but I'll be happy to look into that.
Interesting. Another really interesting question from Rishab. Thank you for your excellent presentation. Can you explain how this structure would fit in the light of the fact that exhaustion of local remedies to explain opportunity to redress disputes by states or means is an established principle of customary international law? Ooh, that I'm not too sure about.
Look, the main thing I am actually advocating here is what I call a balancing act. A balancing act, what I'm saying is investors currently do have a right to bring action against host states without necessarily exhausting local remedies. Now, if there are rights in a lot of IIs, of course, some IIs are not demanding local remedies in there, but most IIs don't. So, if investors do not have to exhaust local remedies, I would argue that harmed host citizens should also be able to go to arbitration without exhausting local remedies. I mean, it's kind of it should be a balance between the parties, but if between the actors. However, if in an II it is thought that that should be put in there, that the hosted citizens will need to go to domestic court before they go to international arbitration, then maybe it should be for both parties. It should be for investors. It should be for host state citizens, so that we have the balance. That's what I would suggest.
That's great. Thank you, Emmanuel. Another question, and maybe it's going to be the last one because I'm conscious of time. It's so late for you, Emmanuel, but another really interesting question from Christopher. What do you think has accounted for the obscurity of the ECOWAS Supplementary Act on Investment, despite its very progressive obligation on investor obligation compared to the much held Morocco, Nigeria, BIT? Yeah, that's the discussion we were having, right? It's an old, so to speak, treaty.
Yeah. To be honest, I am not 100% sure. I would say the problem is that ECOWAS itself hasn't promoted its own instruments. I even think that I doubt that many lawyers in the sub-region, 15 countries of the community members, even know about it. Yesterday, I went to the ECOWAS to try and look at their texts. And this document is basically, in fact, I couldn't even locate it there. But of course, once I went to the UNCTAD website, it brought me there and I could locate this, but I know that it's in existence. So I think it's just a kind of a poor job by ECOWAS itself. It's been a very in African or some developing countries, we have a lot of things that are beautiful on paper, but in practice, nobody cares about them. And I think probably that is one of the reasons. I thought 2008. So you're looking about what 10 years ago, 11, 12 years. I think it's kind of a good document that was ahead of its time.
Yeah.
But yeah, it's remained obscured, which is it's a bit of a shame. It can
Probably you can always blame the famous spaghetti ball, you know, of trade agreement in Africa. ECOWAS is one of so many, and we'll see what happens now with a more uniform trade, environment with the new African treaty, which is less daring, interestingly.
Yes. A free trade agreement. That's much more hype now. So it's a bit more prominent than some of these sub-regional ones, instruments. That's true.
All right. Thank you very much again, Emmanuel, for this really fantastic discussion. Really, really very interesting. Knowing that the issues that you have discussed may seem technical, they are technical, but actually they relate to major issues, major societal issues and violation of human rights. You mentioned Shell in Nigeria, you can mention Bhopal in India, Texaco in Ecuador, you name them. There are so many international, multinational companies which have unfortunately violated a number of extremely fundamental rights of citizens everywhere in the world and in the development world in particular. And as you explained, it's time for action. Thank you so much, Emmanuel, for this great presentation. I know you are, easily contactable if people would like to discuss with you from Monash University website and your email. You've proposed to share some publication, and I'm sure everyone will be delighted to read your work. I'd like to thank the team supporting me, in particular Gloria, Olga, and her, but not only, for the organization and support of the Research Futures webinar. And the last thing I'd like to say to you is that next week we're going to have a new webinar on another really interesting topic by Jose Enriquez Levia, the coloniality of law and the unintended construction of international criminals. So I very much invite you to take part to this webinar as well, because it's going to be really, really interesting. Well, thank you again, Emmanuel. And we're going to bring this webinar to a close. Thanks very much.
Thank you. And thanks to everyone who tuned in.
Thank you so much.
Thanks, Naila. Yeah, you're welcome. See you.